from Generations United. Your speakers today are Anna Beltran of Generations United and Joan Little of Maryland Legal Aid. I'm Jaya Peterson-Lent with Generations United, the Deputy Executive Director here, and I'm going to be moderating today's session. And before we turn it over to our speakers to introduce themselves and kick off the content of the webinar, we have just a few housekeeping items, and Adam Otto with our staff is going to walk through those.
I'm Adam Otto, the Program and Policy Assistant at Generations United. So a few housekeeping tips for the webinar. To hear the presentation, select either mic and speakers to listen through your computer or telephone. So for Q&A, we will have a short time at the end for that, but please type any questions you have into the question bar, and we'll raise them towards the end. If there's any technical difficulties also, please let us know, and we'll also be recording this webinar, and it will be posted later this week or early next week on our website for your viewing pleasure. And then we will also be sending out a short survey after the webinar ends. Please complete it if you're able to. And now I'll turn things over to Anna and Joan to introduce themselves.
Good morning, everyone. My name, or I guess it's afternoon slightly, on the East Coast there. I'm in Seattle. But I am a special advisor to Generations United. I used to direct its National Center on Grand Families. Joan?
And hi, I'm Joan Little. I work at Maryland Legal Aid in the Baltimore City Child Advocacy Unit. I've worked here for over 20 years and have done a lot of work on kinship care issues. Thank you, Joan. We also want to thank the Annie E. Casey Foundation for their support and partnership. They make this project possible, in addition to a lot of our other work. Today on the webinar, we're going to go through a little bit of background, not too much because we assume if you're on this webinar, you're already well aware of kinship families and their needs. We're going to go through some essential elements of these responsive consent laws. So some people call them authorization laws, consent laws, but we're going to go through kind of the elements that these laws should contain. Then what we should avoid in these laws, what aren't good aspects of them, and how we can learn that from what other states have done. Some reasons that states may lack these laws, because not all have them, which is why we're doing this, so you can learn from your neighbors and enact or amend your laws accordingly. Tools and strategies to enact these laws. And then I'm going to turn it over to Joan, who's going to talk about Maryland's experience and its legislation. And then we'll end with resources and Q&A. So that is going to be our agenda today. Now, in terms of the families, there are about 2.7 million children being raised in grand families. And by that, we're defining it to mean not just grandparents and other extended family members like aunts and uncles, but also close family friends, so what's sometimes referred to as victive kin. And many of these children are being raised by these relatives without a legal relationship, without legal custody, without guardianship, and outside of the formal foster care system. So we call them informal caregivers. Some people don't like that term, but it's just shorthand for us to know what we're talking about. And a lot of these caregivers raise the children informally because the whole legal process of getting a legal custody or guardianship can be really expensive, emotionally exhausting. It can put barriers between family members. It can turn grandmom into mom. There's just a lot of reasons that some caregivers, it's not the right option for them. For many it is, but for some it's not. And you know, many caregivers hope that someday the children will be able to return to the parents' home, so they want to keep it informally. But without a legal relationship, these families often face many barriers, especially accessing health care for these children and accessing educational enrollment and services. So what happens is doctors, even if these children have health care insurance, you have to consent to health care, right? You have to have a parent or guardian who will say, yes, please treat my child.
So what these laws allow to happen is that grandma or aunt and uncle can have this piece of paper that they've signed that says, I'm caring for this child, and then they can present that to the healthcare provider and have them provide care. And so this can work very well for them. Another big challenge is the enrolling the children in school. And the reason that it's challenging for these caregivers is because most states have what are called residency requirements, and they're based on where the parent lives. So where the parent lives, that's where the child gets to go to school. And if the child doesn't live with the parent, then many states or school districts require that that caregiver have legal custody or guardianship. And they do this not to be difficult, but because they want to avoid people shopping for schools. You know, a high school X has a better football team, so I'm going to use my mom's address to enroll my child in school, even though my mom, the grandma's got nothing to do with raising the child. That's the kind of thing they're trying to avoid. But the problem is these kinds of requirements inadvertently and unjustly prevent children who are being legitimately raised by grandparents, aunts and uncles, and other extended family from enrolling in school. And then a little catch-22 that can happen is that then the caregivers are also being held responsible for violating truancy laws. So not only can they not enroll them in school, but then they're on the other hand, they're being held responsible for not sending the child to school. So they're really getting it both ways. So what these consent laws, and that's what we call them, probably just mostly because of longevity in this area, and that's what they were called from the beginning. But now more and more states are calling them authorization laws because of concerns that connotations around pregnancy termination. So many states are calling them authorization laws, but just know that's what we're talking about. And basically what these laws allow is a caregiver, like a grandma, to complete an affidavit under penalty of perjury that they are the primary caregiver of the child. They're taking care of this child. And then, like I said before, by presenting the form to the healthcare provider or the school, they can access those services. Now, some people, worry about parental rights and that perhaps it doesn't protect them well enough. And so these laws typically can put, and typically do put provisions in the notices section of the affidavit saying that this doesn't confer legal custody and that the parent's rights are intact. And they also shield healthcare providers and schools from liability from relying on the affidavit. So they're protected. Now, California seems to have started this trend back 20 years ago when it passed the combined educational and healthcare consent. And now, and take this number with a grain of salt because it is very hard to track 50 states. And so we do rely on people telling us about legislation. So if you see a state, if you see a state that's missing, please let us know because you have to use exactly the right search terms for that state to be able to capture this legislation. But we think we've pretty much got it, and that we have 25 states that have healthcare consent and 17 that have educational consent. And we want to point out that the Annie Casey Foundation's report, they did a kids count essay last year, no, I guess it's 2 years ago now, 2012, called Stepping Up for Kids, that we still rely on a lot. And it recommends that states without these laws enact them, and that's what we're building on here. So we distinguish, well, let me first talk about the consent laws among the states. So here in the Northeast, you will see the states that have these laws. Now, you'll notice down at the bottom, D.C. and Massachusetts and Pennsylvania have these laws. They call them consent laws. But for purposes of this brief and this webinar, we don't consider them consent laws, and that's because they require the parental signature and the parental to convey authority, the parent to convey authority to the caregiver. So we really consider that more of a power of attorney law. We make that distinction because these laws, what these consent laws and authorization laws, who they can help, are caregivers who can't find the parents, or the parents are out of the picture, or the parents are unwilling to sign any kind of legal document. So we feel it's important to have this option for them. Power of attorney laws are great when the parent's in the picture, but they don't work when the parent's not in the picture. So speaking of power of attorney laws, how they work is that the parent completes the document that states what type of authority they're conveying. And they can pick, education only, healthcare only. They can do it however they want in most states. But as I said, this can pose a real barrier for some of our grand families when, they're just not willing to sign this kind of document or they can't be found. And power of attorneys are generally convey more authority. They confer all powers over the care of a child, with the notable exceptions of consent to marriage and adoption. But they can be, if the parent's in the picture, they can be a very good option for informal caregivers. And then on the next slide, you'll see some of the states that we've identified that have, most states, if not all, have power of attorney laws. These states specifically call them out for parents conferring authority to caregivers. So that's why we've got them listed here. And you'll see we have D.C., Massachusetts, and Pennsylvania listed for the reasons I mentioned before. Now let's turn to essential elements of responsive consent laws. But I need to take a drink of water. It's a lot of talking. Anyway, you'll see on the next slide that there are quite a few elements. And what we did here was we read all 25 healthcare consent laws and all 17 healthcare consent laws and really tried to pull out what we thought was the best, leave what we didn't like, and we'll identify that too, and really give you states language to replicate, some places to go, so you don't have to reinvent the wheel. You can start from what's out there already. And Kentucky just passed a law this year, or in April, and they said that that was so helpful to them to have language to build on, and peers like in Virginia to talk with. So that's what we hope to accomplish here today. The elements to include are putting the form for the affidavit in the law itself. That helps later on so that you don't have to do that during the implementation phase of the law and then perhaps get a lot of people wordsmithing, basically. Cover comprehensive health care and educational services. Allow the caregiver to complete the form without the parent's signature for the reasons we talked about before. Really addressing those parents' rights and making sure that we're not infringing on them. Shielding the providers from liability. Specifying the penalties for fraudulent consent. So really getting specific, especially there in the educational realm. Allow the consent to be valid until it's rescinded, so don't put a one-year limit on it. And permitting all full-time caregivers, so that victim can, again, to complete the affidavits. And go through this in a little more detail. So basically, on the next slide, you'll see that if the form's in the law itself, it can be easier for the caregiver, because there it is. There's one form for the whole state. You don't have a bunch of counties doing different forms. The caregiver can just go to the law library or online now and get the form. And it's helpful if the laws are combined. So if the educational and healthcare consent law is in one law, because that way it's just one form, right? And it's also simpler for school districts because they need healthcare information too. You always have to submit as a parent or caregiver immunization requirements, all that kind of thing. But whether they're combined is really not as important as the forms are readily available. So we just want good forms and in the hands of caregivers so they don't need to consult lawyers. That's really the purpose of this. Let's make it as simple as possible, as cheap as possible, so caregivers can access the services they need for the children. As far as I know, there are no joint consent forms in the Northeast that cover both. It's a two-form process. If that's wrong, please let me know, either in the right-hand panel or emailing me separately, because I'd love to hear from you. On the next slide, you'll see an example of a combined form. Because the Northeast doesn't have one, I pulled one from the South. And this is from Louisiana. And when you start looking at these across the states, you'll see that they really have copied each other. That Louisiana and Montana are very similar, and they couldn't be further regions of the country. But you'll see how simple it is, really. You write the name of the child, the date of birth, the caregiver's name, their address. You see there's a checkbox there in 5 that they're not a non-legal custodian. And then, so if you can't locate a parent, then you check one of these. So they've either received no objection from the parent that they've contacted, or they're unable to contact. the date of birth of the caregiver and the driver's license, and then you'll see the penalty warning, right? So don't sign this if this is not true, if you are not the caregiver, because you're signing under penalty of perjury. And then there are all the notices, and you'll see this on every consent form. So again, you'll see in number 1, it doesn't mean that by signing this form doesn't mean you have legal custody, so you don't have legal custody, and that a person who relies on this affidavit, so a healthcare provider or school, has got no obligation to ask more questions. This will do it. And on this one, it's not valid for more than a year, so they would have to do another form when the year expires. We recommend not taking that approach and just letting it continue until it's rescinded by the parent or the caregiver. And then there's additional information down below. So they're really very straightforward. The last one, it doesn't confer dependency for health care coverage purposes. That would depend on the kind of health insurance you have in your state to see if you'd need that kind of provision. Most states don't have it, but some do. All right, now we want to see these states cover comprehensive health care services. So some of these consent laws only cover immunizations. Some only cover medical care, and then they don't define medical. So what we want to see is all of these kinds of different services covered. Because a lot of the children being raised by grandparents and aunts and uncles have special needs. So it's important that we let these caregivers access all those services and consent to all those services. You'll see that Delaware includes mental health care. It's interesting because like Washington State didn't have mental health care, and it really was just an omission that they just didn't think about it. So they went back and amended that. So really just thinking about all those different kinds of health care. And then covering comprehensive educational services too. So we all think of educational enrollment, but there's a lot of other services that are important. So I'm pulling out Delaware's law here because you'll see it highlights a number of other things like special education, like serving as the contact for the school. So because the school might not be clear on who they're supposed to contact, parent, the caregiver. So this really makes it clear that they're supposed to contact the caregiver for any problems or any issues about the child or any needs. And then it also takes the onus off the school from communicating it with the parent. But now it's really supposed to communicate with the caregiver. Now another big thing in these consent laws is not to require the parental signatures. And as I talked about before, we're not calling any of these laws that require parental signatures, we're not calling them consent laws. We're calling them power of attorney laws. Addressing parents' rights is another big area, like I mentioned earlier as well. And you can include that in the notice section like Louisiana did. Here's an example from Maryland's, and we're going to hear more about Maryland's in a few minutes. But there's some language that you can borrow and not reinvent the wheel. You also want to shield providers from liability, and you can do that using some of this Delaware language. The providers have no duty of further inquiry, so they don't have to ask any more questions. And they're protected from all kinds of liability or disciplinary action because they relied on the form. But then I think this last bullet's important, or the second to last bullet's important, that providers can still be held liable for negligence. So this isn't this isn't a get out of jail free card, but it's the consent doesn't change. The consent allows them to access all kinds of services, but the providers aren't liable for relying on that consent. But just like caring for any child, if they do something wrong, they could be held liable for medical malpractice. So it doesn't protect them from that, just like a parent's consent wouldn't. Shield schools from liability. Now this can be similar language, not conducting further, not required to conduct further inquiry. So not asking questions like, why isn't the parent raising the child, or why are you, or all that kind of thing. and also not being subject to any kind of liability. Louisiana has an interesting provision there at the end that you could borrow, which is it's extended, the protection's extended to schools for situations where the parent would have made a different decision, but the school didn't know. So that protects the school further, because that could definitely happen. And then specifying penalties for giving fraudulent consent. This is a big area, especially in the school arena. Not so much in the healthcare arena. The penalty of perjury seems to be enough to deter people. We don't hear, talking to the states, talking to people who have these laws, we don't hear a lot of problems with these laws in terms of people using them for false purposes. Kentucky had a good point, and Virginia had a good point, that if you're going to shop for schools and do those kinds of behaviors, you're not going to flag yourself by submitting an affidavit, because that's already going to put you under a higher level of scrutiny. You're going to try to fly under the radar. So we don't see problems with these laws. I don't hear about them. And you'll see that some states are, some states are more strict about the school penalties than others. New Jersey in particular has quite a bit of protection, including because penalty of perjury is not something that perjury is not something the criminal justice system is going to go after with a great deal of zeal. New Jersey has set it up so that the school board can impose the penalties instead of going through the criminal justice system. So the school board can remove the children. It can charge the tuition cost if they were fraudulently attending another school. It can impose monetary penalties. That's the only state that I saw something like that. But if that would fly better in your school, in your state, then you could consider that. I talked earlier about how states shouldn't put automatic time limits. That 1 year, it's just more paperwork for everybody involved. The caregiver has to do it every year, the school has to take it every year, the healthcare provider. So really make it valid until rescinded by the parent or by the caregiver. And then last, in terms of these elements, is permit all full-time caregivers to complete the consent affidavits. And by this I mean those victim kin that we talked about earlier. So maybe a godparent is raising a child, or maybe it's a very close family friend that's like an aunt to these children, but they're not related by blood, marriage or adoption. Allow them to use these forms as well. And only a few states really do limit them. Most states do allow all caregivers to complete these forms. And only one state limits it to just grandparents. That's Ohio. All right, moving on to the next area, which is elements to avoid in these responsive consent laws. So there are a number of things that we don't want to do, which is not allowing the local school districts to decide whether to accept the affidavit, so creating a state law and then leaving it up to the states whether or not they want to take it or not. I mean, sorry, not the states, the school districts, whether or not they want to take it or not. Not requiring sworn statements from the parents, and then minimizing those documentation requirements. So let's make this as easy as possible. So you'll see on the next slide where, and I only saw this in one state, it was Oklahoma, but it left it to the discretion of the local school districts whether or not they could, whether or not they would take these consent affidavits. And it was interesting because I just was at the Brookdale Foundation Relatives as Parents Program conference, and I had a lady from Oklahoma in my audience, and she raised her hand and said, well, I see you could list Oklahoma as an educational consent law, but my caregivers in my county can't use it. And I pointed out this nuance of their law, which I would not recommend, because there's enough variation among school districts anyway, as you'll hear from Joan. So you want to minimize that. Not requiring sworn statements from the parents. So these kinds of things where you're having the parent say, kind of admit failure, basically. I'm not capable of supporting this child. I can't do it. So, and the child's not residing with my grandma, with my mom, because of because they just want an education. This is because I can't do it. So, really not requiring families to go through that. And also, these kinds of requirements can be hard, too, because there are a lot of federal health care protections, HIPAA and all that, and it can be hard to get that information. And of course, parents can share anything they want about themselves, but the caregivers, it can be really hard to get that information to share it. And you'll see Virginia, again, gives local school districts discretion, not in whether or not they can take the affidavit, but in whether or not they're requiring these kinds of statements. And it's better to avoid that kind of thing. And then related to this is don't require, a lot of documentation, like the reasons the parent's unable to parent, like I mentioned. They can be really intrusive. These families usually have enough drama without having to, to tell everybody all their business. I mean, nobody wants to do that anyway, so why make them do that? Now, reasons some states may lack consent laws. So these seem to make sense. Why don't all states have them? Well, there are various reasons, and some which are, very legitimate, which is there might be an alternative way to enroll the child in school. So there might be, like in Indiana, the child's residency is where the caregiver lives. So, they don't have this problem. So whoever's caring for that child, that's where the child lives. Consent from military families, and I'll get into the specifics of that in a second. Power of attorney laws, which again has been a good reason. Open enrollment laws, that you can enroll the child anywhere in the state. That might work if you can get the parent to do it. Parents' rights, they've been strong opponents in some states, in other states not at all. And school objections. The K through 12 community has been usually in most states the most vocal opponent, and they're a stakeholder you want to get on board early because they can be great as well. I mean, it's just they have their legitimate concerns. So in terms of alternative methods to enroll children in school, like I mentioned, Indiana's got that first one, so does Rhode Island. So there are states that have that kind of provision, and maybe these laws aren't necessary for them. The consent for military families, this is interesting. This interstate compact on educational opportunity for military children, this is a law that has been adopted in almost all the states, well over 45. I can't remember the exact number, and it changes every year, but they are almost nationwide. And this is an interesting law because it helps those children who are being raised by caregivers because their parents are deployed or they're on a base somewhere else and someone else is taking care of them while their parents are unable to. This is one of the reasons that kinship families come together because their parents are in the military, but it's just one of many. So this really just helps a subset of our population, not all of them. But if your family, if there's a grand family that you're helping, that's the reason they formed, this is the route to take because this law is more comprehensive than the kind of laws I'm talking about today. This law not only allows them to enroll the children in school and access educational services, it also, say the child has moved from Louisiana to Alabama to live with grandma, well, and they're in high school, well, the Louisiana graduation requirements apply, not the Alabama. So you wouldn't have a senior, leaving home and having to meet all kinds of new requirements in another state. So kind of their home state requirements follow them, which is very nice. It's a very nice law. I put the website there so you can take a look at it. Perhaps you can borrow some language from it as well. Power of attorney laws, for the reasons I talked about before, they are a great option to have for some families. Well, and they're a great option to offer, but they only work for some families where the parents are willing and able and available to convey the legal authority and to sign these documents. And then open enrollment laws, again, this requires action by the parent to say, I want my child enrolled there. So that might not work where the parent's unavailable. Tools and strategies to enact these laws. There are a number of strategies that have worked. and you'll see this big long list here. You know, really educating that those existing alternatives like power of attorney aren't enough. Protecting parents' rights, not against parents' rights. Protecting parents' rights. Involving educational stakeholders, so that K through 12 community. Making clear that these laws are cost neutral. This is why we're seeing a lot of activity in these laws, I think, lately, because it's a way to help kinship families without any cost to the state. And I think more and more states and the media and the public are acknowledging that grandparents and grandfamilies are providing a really valuable service. They're really heroes. They're stepping forward. The media portrayals are very positive. We've really stopped hearing about that apple doesn't fall far from the tree nonsense. So this is a way of helping those families without any cost to the state. So in the last, in 2003, we saw 2 states enact these laws, and in 2014, we've seen another 2, Kentucky and Missouri. So they keep growing. Protecting against liability and fraud, using community partners to help advocate, so really thinking about those partners. And then separating educational from healthcare can be a strategy, which Joan is going to talk about because they use that in Maryland. And sharing personal stories. I mean, good Lord, everybody wants to hear the personal stories. They're the most powerful thing. Really getting the caregivers up there and the children up there to tell their stories. It is the best advocacy tool. So in terms of educating that existing alternatives are not enough, we've touched on this now several times, that these power of attorney laws, these open enrollment laws, they're just not responsive to many grandfamilies because the grandparents can't locate the parents, or perhaps they have mental health issues. The parents have mental health issues, and they just they're very concerned about signing a legal document. They don't understand it. There's just a lot of reasons that these don't work for many of the families. Protecting parents' rights, this is a big area. So really putting it in there, putting it in the affidavit, stating that the affidavit doesn't confer legal custody. And asking for the parents' signatures can be a compromise, but don't require it because then these laws really are power of attorney laws. But I don't think you need to do that last thing. I think that it can be done perfectly well in the notices section, and we really haven't heard. We've heard concerns, but not actual problems. Involve educational stakeholders and respond to them. So, really at the beginning, before you even start introducing legislation, get a couple of school leaders on board. They can really help you identify the challenges. And, there really are systems in place in most states already to address school shopping. Unless they have an open enrollment law, they're well aware of this problem. It exists everywhere. It's not our families who are doing it. It's, it's parents who want their kids to attend, a school because it's better academics or better sports or whatever reason. So there really are already systems in place for that. They can help you throughout the process. And you can respond to their concerns. If you hear them, you can figure out ways to respond to them with those strict penalties. Perhaps you can set something up like they have in New Jersey, including a process to challenge the affidavit, so like they did in New Jersey. So get them on board early and really have them help you. The next one is a big one. Really make clear that these laws are cost neutral. There's no program implemented here. There are no salaries to be paid. There's no administrative costs. But they really can help kinship families. So it's a nice alternative. And I was talking to Washington State the other day, and what they do sometimes is they put this consent law in place. They put a consent affidavit in place while they're getting legal custody. So at least the caregiver, maybe the caregiver does want to pursue legal custody, but this gives them something in the interim. So it's really an important option in a lot of situations. Protecting against liability and fraud. Really using those liability provisions, that we talked about earlier. So protecting them against relying on the affidavit, but not immunizing them against negligence, against malpractice suits, but protecting them from relying on that affidavit. and using penalty provisions to protect against fraud. And there really are systems already in place for schools, but these laws can make it super clear. And then using community partners to help advocate and share personal stories. The power of the personal story is huge. I hear them all the time, and that's what we rely on. Jaya Lent, our Deputy Executive Director, does a lot of advocacy in Capitol Hill on behalf of these families, and she can tell you that it's the stories that are what resonate. We've held grand rallies on Capitol Hill, and that's what people really respond to, is hearing from these families, and that's what gets this legislation moving. And community partners, really using them. And here's a list of some people that you can include and think about, but there are a number of others. I'm just going to share a couple stories with you. I was just listening to this the other day from Kentucky, and this resonated with them. There was a little boy who really needed earplugs, a tiny boy, a baby. And he went 6 months without his earplugs, doing potential damage to his hearing because they couldn't find a parent, and the doctor wouldn't do it without consent of the parent. So, it's these kinds of consent laws that can respond to situations like that. Years ago, in the District of Columbia, I remember a case where a boy had been put on the bus by his mom to go live with Grandma up in D.C., and Grandma could not get him enrolled in school, and he went without school for 6 months. So it's stories like that that are really powerful, that resonate with everybody, that you can get bipartisan support for, that are very, very powerful. I am going to turn it over to Maryland, to Joan Little, to talk about Maryland. And here's another stakeholder that you want, and a community partner that you want involved early on, which is the lawyers, because they do a great deal for these families, and you really want to get their buy-in. So Joan, I'll turn to you.
Thank you. So in Maryland, we were looking for a way to deal with a number of different issues that had arisen as a result of informal kinship care providers issues. One is we had a large population of kinship care providers in foster care, and the state had an interest in not taking in as many of those caregivers if they preferred to be informal. But those same caregivers weren't able to make decisions for the children that they had in their care, and that was the problem. So an informal caregiver, although they have physical custody of the child, they don't have complete custody of the child. So all our kinship care affidavit legislation sort of assumed, okay, the caregiver has physical custody, but not necessarily total custody of this child. The parents have retained total custody. The only right over a child that we were really talking about was the guardianship right for health care. And the reason we were talking about that right in the health care legislation is because we thought, okay, that is something that a person who's taking day-to-day care of a child really needs to have the authority to make health care decisions when they can't reach the parents. So that sort of was the context with which we began to try to figure out how to go about writing up this legislation. And actually the senator in our legislature that went forward with it was Senator Dolores Kelly. And what I loved about her approach was that she said, okay, let's describe the hardships that would make a caregiver qualify for this affidavit, for this type of consent law. And so we have a list within our legislation that specifically says, serious family hardship means death of a parent, serious illness, drug addiction, incarceration, abandonment, and military duty. So we have very specific criteria that allow this affidavit to be used. And I would recommend that to anyone who is thinking about pursuing this kind of legislation, to think through what the criteria are in your state that would make sort of the best choice for consent legislation. The second thing we did that I thought was really effective was that the affidavit is lodged within the legislation. And what Anna referred to earlier, and what is so important about that, is that the form is already there. There's no opportunity for local jurisdictional squabbles to change the form. It is what it is, and if it needs to be changed, you have to go back and amend the legislation. So I think that was particularly effective. And later on, when we went forward with the educational consent law, same thing, the affidavit was lodged right in the statute, and it basically mirrors the healthcare statute. Now, I don't know, we have not heard any complaints in Maryland about caregivers who've been turned away for healthcare services with this affidavit. But I will say the language in our statute simply allows the caregiver to consent to healthcare on behalf of the child, as long as there's no one else that has custody, and as long as the affidavit has been presented. Excuse me. I don't know that there have been any complaints about that. I haven't heard of any. So I'm assuming that that language, healthcare, is broad enough so that the doctors are accepting it. I would say, though, that in crafting one's own legislation, that is something to think about. What is the wording there that the doctors really need to have in order to consent to the broadest amount of health care problems? And I guess in the back of my mind, the question is sort of, should that language include some kind of HIPAA language? Ours does not, but I don't know whether that would be a good idea to include that or not. The other feature of our legislation for health care is that you do have to annually go back and go to the health department, get the form, and reaffirm that you're still a kinship care provider for that child. I did have a chance to speak with our state agency that monitors these affidavits, and they're not seeing that people come back annually to reaffirm their affidavits. Maybe that doesn't matter. I don't know. The weakness in that, of course, is if the caregiver has changed. There's no way to know unless that new person comes and applies for a new affidavit. Within the body of the affidavit, you sign the affidavit under the penalty of perjury, so that is the only mechanism for a remedy if something goes wrong with the affidavit, or if a person tries to commit some kind of fraud. Honestly, with the healthcare piece, I'm not sure what kind of fraud one would really try to perpetrate, but at any rate, if so, there is that penalty of perjury in our statute and in the affidavit. And finally, a relative providing kinship care can apply for medical assistance and public assistance for the child. That was important language in our statute because most of the kinship care providers who utilize this kinship care affidavit are ones who need medical assistance for the child at a minimum. They may also need our temporary cash assistance program or WIC program, but they definitely need the medical assistance program. And finally, our statute indicates that this doesn't abrogate the rights of the parents. And that was critical. Our parent representatives were a part of passing this healthcare affidavit law, and without them, we couldn't have passed it. So I think making sure that all the stakeholders are addressed and can be heard and whose points of views are included in the statute as much as possible, that's a critical piece of getting the legislation passed. Ultimately, I think that for Maryland, the healthcare affidavit has prevented some children from coming into the what is normally our juvenile court door to get custody. What normally would happen in the past is a caregiver would call social services, they would say they needed a custody order, and that case would be brought in through the juvenile court with the involvement of social services to get a custody order for that relative. And now that is happening less and less. It will still happen in cases of abuse and neglect where the case belongs in the juvenile court, but we don't have those cases where the parents are not really around, but they haven't really abused the child. So I think in that way it saved our state quite a bit of money, and the only cost, if you want to call it that, was that of printing out the affidavit form. So I think very minimal cost, and ultimately a savings for the state because less children had to be engaged in the more formal systems to get custody transferred. I think for informal caregivers, there's always that other piece, which is, the hesitation of wanting to go up against a parent to get custody, even if it's the right thing to do for the child. That sort of familial tension may often be too devastating for the family, and there are lots of good reasons why caregivers remain in that informal status so that they don't have to go up against the parents. So then the next one was the legislation for the education affidavit. It took us a little longer to get that legislation passed. The reason for this was in our state, each child in each jurisdiction is supported by the property tax. So it's the property tax in a jurisdiction that determines how much money is spent on a child in the school system. And of course, that's different throughout the jurisdictions. So there are some jurisdictions where children, quote unquote, come with more money, so to speak. And the other jurisdiction that was receiving the child would want, the jurisdiction that was receiving the child would want the same compensation as the jurisdiction that was losing the child. So Senator Kelly again worked on this bill and had to work with the various jurisdictions to work out a reciprocity arrangement so that a child that was moved from one jurisdiction to another, that there was some reimbursement for the difference in the cost of education in both, in the new county versus the old county. Again, we have declared what hardship means within the statute. We have the affidavit in the statute. What is different about the school affidavit is, the educational affidavit, is that there is a provision that if there is fraud or misrepresentation discovered, the county superintendent shall remove the child from the school immediately, and the person that enrolled and made the material misrepresentation is subject to a penalty for 3 times the pro rata share of tuition for the time that the child fraudulently attended a public school. So that is a pretty hefty fine for an informal caregiver who is likely not to be particularly wealthy or sophisticated. But I guess that's what had to happen in order for us to get this legislation passed. There had to be a meaningful way to remedy this problem that caregivers sometimes try to forum shop for different school systems. The educational affidavit also has to be updated annually, and it should be updated about 2 months before school starts. I think there might be a specific provision as exactly when it has to be updated, 2 weeks before school starts. Again, I don't have any information that those updates are actually being done. We haven't heard really any complaints about the kinship care affidavits other than those complaints that came up during the passage or the attempted passage of the educational legislation. We don't think that there is significant fraud going on because basically what we're dealing with is families who are struggling with parents who are, either addicted or have mental health problems and are just unable to care for their children. These are not wealthy families. So for the most part, if a child is actually living with that caregiver and they filled out the affidavit, that generally is actually what's happening. There isn't that much fraudulent perpetration going on in this area. The school superintendents, as far as I know, have not been particularly forceful about trying to get documentation about whether a child is actually living in a particular home or not. Again, I think the issue really has come down to people that use these affidavits aren't really committing fraud. So if you were, you wouldn't fill out the affidavit at all to begin with. So although there is a provision within our educational consent law that allows the superintendents to ask a second and a third question, get the supporting documentation, that really is not a huge problem, and it's not something that the school system is having to spend a lot of resources on. So that's pretty much what happened in Maryland, and I do think that transferring these pieces of the guardianship rights that parents hold to the actual caregiver of the child, as a general rule, make a huge difference for the smoothness of the day-to-day care that a relative gives to a child. That really, it is just so much more cumbersome to have to go find the parent and go to the school meeting, or find the parent and go to the doctor with the parent, whether or not the parent actually has the capacity to make decisions that day. These two pieces of legislation have really solved that problem in Maryland, and I think they were a terrific solution to a very difficult situation. Anna, that's what I have.
Thank you so much, Joan. Appreciate it. In terms of resources, there is a policy brief that Generations United put together, and it covers in detail a lot of the things we talked about today. You can download it from the Generations United website or from the grandfamilies.org website. I actually just updated it today to include 2 new states, which is Kentucky and Missouri, that enacted laws back in April. Missouri actually expanded their health care and then added on educational. And Kentucky started from scratch and enacted both together. So that's a policy brief that's available to you free of charge. There's also a summary, 3-page summary that goes along with that that you can get down from those websites as well. Then there are a number of other websites that are available as resources. Grand fact sheets might be particularly useful to you. There are 50 of them for each state. Well, I guess there are 51 for each state and the District of Columbia, and you use a drop-down menu and you can pick your state. And they're somewhat outdated, but they provide people with a starting point in terms of what's available in their state, services, support groups. So it's a nice thing to be able to hand caregivers. And the grandfamilies.org website has all this legislation on it in a database. It also has analyses, and it has a separate analysis of these kinds of laws. So it's a big resource. We work on that with the Generations United, the collaboration between Generations United, the American Bar Association, and Casey Family Programs. And then, of course, our own website, which has a lot of information on it, gu.org. And you can sign up for e-alerts on the home page in the right-hand panel and get alerts on public policy and what's going on, especially at the federal level. And then a couple of other websites on the next slide, I believe, which you can also access. There's the Brookdale Foundation Group, which is the largest national network of support groups and services for the families. And they know a tremendous amount they've been around for a very long time, and so they know about laws, they know about everything, so they're a great resource. And then last but not least, the AARP Quick Link, which can help families figure out what benefits that they're eligible for, because as we alluded to, a lot of these families are low income and can use benefit support, and very few families actually access the benefits they're entitled to. Only 12% of our families access TANF child-only grants, even though almost all of them are eligible. So getting the word out to them about that is also critical. And then on the last slide, you will see email links for myself and Joan and Jaya. Feel free to reach out to us with any questions, concerns, follow-up, and then our 2 websites are at the bottom. And now I'd like to open it up for questions from anybody who's got one.
Great. So thank you, Anna and Joan. This is Jaya Lent again, and we have been receiving some questions from the question tab. Feel free to continue to send them if others come up. The first one is about getting the PowerPoint, and just to let folks know, all those that registered, we will follow up with a link we will be posting this webinar on our website, and so we will post a link both to the recorded webinar and a place where you can download the PowerPoint so that you can share the link with others that might have been interested that couldn't attend, and you'll also have access to the PowerPoint afterwards. The second question that I'll raise is one that came out of a school district in Washington State that apparently doesn't allow students who are not in the legal custody of their caregiver to participate in extracurricular activities. And the question was, have you seen any special ways of addressing this situation in these laws?
Well, that's an interesting question. I'll just chime in and I'll turn it over to Joan. There are some states that in their consent laws specifically allow caregivers to consent to extracurricular activities, co-curricular activities. So you can construct these consent laws, and I know Washington doesn't have an educational consent law, but they were, I've gotten some calls with interest in pursuing that. And that story would be great to capture. So if you could send it to me, I will share it with the people who are pursuing that law. But you can structure your educational consent law to include extracurricular and co-curricular. Hawaii does. Joan, do you have anything to add?
Yes, and then in our state, the main hurdle was enrollment. So our legislation, if you read through it, really focuses on giving the caregiver the ability to enroll the child into the program in their county. And from that enrollment, they get all other services. They would not be excluded from afternoon sports, say, if the child is enrolled. The hurdle is enrollment in Maryland. So that's how that was addressed. And in fact, when our legislation was first enacted, our biggest hurdle was trying to inform the county, the various counties, that this law had taken effect and that the schools were required to have the form on site, and they were required to give it out to people who said that they were informal caregivers and who, you know, fit the criteria of within the affidavits.
That's a good point, Joan. None of these laws are any good unless people know about them, and we've heard that with another kind of law that helps these caregivers called de facto custody laws, that a lot of judges and lawyers just don't know that they exist. So really getting the word out that these things are there and having the forms available is a huge part of implementation.
Great. So another question we have is, what is the process for parents to rescind consent? And if consented, or if contested, what is the court process? So I think I'd go to Joan, and then Anna, if you have anything to add from other states that you're aware of.
Sure.
The statute does not, in Maryland, does not presume any court process. A parent, if a parent objects to a caregiver having the health care or the educational affidavit, they would simply go either to the school or to wherever the health care affidavit is located. For example, normally if a grandparent is caring for a grandchild, they would give the health care affidavit to their practitioner, to their GP, to the pediatrician. And if the parent disagreed, the parent would go to the pediatrician and say, you know, I don't agree, I'm the parent, and this affidavit does not abrogate my rights. So we have not had any parents needing to use the court system in order to override these affidavits. But honestly, again, the population of families that's using these affidavits are not, these parents are not coming back and saying, hey, you know, I disagree with this healthcare affidavit. They're mostly allowing the grandparent or whoever to care for their child and have the ability to make healthcare decisions, and there isn't really any remedy to override that being sought.
Just to piggyback on that, most states, the process is just going back to the, like in Maryland, just going to the school and the healthcare provider and saying, you know, I'm taking care of the child now, and I'm rescinding those affidavits. Ohio does have a process where they have to file. The Ohio law is limited to grandparents only, and they have to file their affidavit with the court. And then the parent goes to the court to rescind it. We don't necessarily like that approach because it does require going to the court. It is a free filing fee, but if that's a problem in your state, if that's an opposition you're getting, that is a way to address that issue. New Jersey also requires the parent to file. Well, that's a little bit different, so I don't think I'll get into that. But anyway, Ohio is something to look at if you're concerned in that area.
The other leverage is the annual re-enroll, you know, re-upping the affidavit. I mean, if a parent really objects to a caregiver having their, you know, having a health care affidavit or something like that, I mean, it's only good for a year. So not only can they go to the health provider immediately and say, I want to take charge of this situation. Within a year's time, there's no question that that affidavit is no longer valid.
Anna, I'm wondering if you would want to respond to that because the recommendation is actually that they aren't time limited.
Yeah, I mean, we don't necessarily like the time limits, and, you know, I do wonder if the schools, I think it would work fine to have that time limit, I mean, in terms of actually being implemented, but I do wonder if doctors are actually noticing that they expire. But it can be a solution. I mean, I personally advocate any compromise that needs to be reached as long as it's not too onerous on the grandparents, that these laws are important enough that, you know, do what you need to do to get them passed. Just make sure that they work for the caregiver. So if it's a 1 year, if that's the concession, make it.
Thank you. And then we have another question specific to Maryland, and that's, so Joan, do you know of any times that a caregiver has been found guilty of fraud and charged with the 3 times pro rata of tuition?
None that I know of.
Okay.
Yeah, I'll reiterate that I haven't heard any states, you know, that have problems with these laws, actually having to go and impose penalties, or it doesn't mean it hasn't happened, but I certainly haven't heard of it. There's been in many states concerns during the passage phase that you know, things are going to happen, but they actually have not come to fruition.
Okay. Just a couple more questions coming through. And here's one about the Maryland law names those specific criteria that you raised, Joan, for qualifying. And the question is, have you heard about any people who don't fit the criteria who have been missed by naming the criteria?
No, I don't know of any situations like that. They're broad enough, and they cover basically all the issues that our parents have that are in this situation. There's serious illness. That captures almost everything.
Great. And then there was a note that it looks like Maryland does not include this, but do other states include any HIPAA language in the laws? So Anna, I think.
No, I have not seen any HIPAA language in any of the other laws. I wanted to ask a follow-up to Joan, actually, if I could. Joan, didn't they amend the Maryland law based on that documentation, that it was becoming a little bit too onerous, and they changed it a little bit? Is that accurate, back a couple years ago?
Yes. Yes, you're talking about the educational affidavit. And
yeah, the educational one.
Right, right. They sort of softened it, saying that the superintendent may ask for the documentation. Again, you come back to people that ask for this kind of affidavit to enroll a child in school. They're not being fraudulent. There's no reason anybody would come and ask for an affidavit, make themselves known to the school system if they were trying to perpetrate a fraud.
That's definitely what I've heard around the country.
Right. Okay, and we have 2 more questions. The next is on the educational consent laws. Have we seen laws that also cover early education for children who are not yet school-aged? So early intervention services, for example, for children who are not yet school-aged.
That's a very good question. And no, I didn't see that specifically. And that would be a good thing to put. I'm thinking one could argue, but it would be an argument because I don't think I saw it anywhere specifically. I will take a further look, though, and I can get back to that person. You have their contact information, Jaya?
I have. Right. Great. Okay, we have their name. Great. Thank you. And then finally, the last question I think that we have, this one is for Joan, and that's in moving the Maryland law, what stakeholders were particularly important to move it forward?
Well, it starts out with a legislator who is ready and willing to sort of guide something meaningful like this through the process. It's very time-consuming. It's not sort of the kind of legislation that's going to win you all kinds of support in the next election, but you have to find a legislator that's really committed to the issue of kinship care and has a lot of leadership qualities. And then the other important stakeholders were clearly the state agencies that would be touched by these affidavits. On the healthcare side, it was mostly the Department of Human Resources, and on the education side, it was a little more complicated because you needed not only the overall state agency to support the bill, but you also needed the locals to support the bill. And I suspect in lots of jurisdictions, that's the issue, that there's always going to be a couple of jurisdictions that don't like the way the affidavit or the consent law will impact their school system. So that was critical. Then we needed lots of caregivers to tell their stories, and we had a number of them, and also parent advocates in whatever community you can find them. In our particular situation, the Office of the Public Defender represents parents in our child abuse and neglect proceedings, and they were a strong advocate for this law because they recognized that it was a way for a parent to have an informal caregiver care for their children without requiring an official court process that might result in removal of custody and guardianship from the parent. So we had the very strong support of parent advocates, and that did make a big difference. And child advocates as well. We have a fairly organized child advocate community that supported the bill.
I'll add that I talked to one of the advocates from Maryland, grandparent caregiver Pat Owens, who really worked hard on this bill, and she gave me a little anecdote, which I'll share with you all. And this is what we hear a lot with these consent laws, is that if grandma, say, knows the office manager at the local school district and maybe went to school there herself, usually no problem enrolling the child anyway, right, without a consent law or whatever. She knows that Betty Sue is raising Billy Bob or whatever it is, right? But if you don't know, it can be a challenge. So anyway, there's this grandma in rural Maryland who had enrolled her grandson, Johnny, in the elementary and middle school, no problem. This was pre-consent law. But then when it came time to enrolling him in high school, the high school said, sorry, you need a legal custody order. And so he couldn't go to school, so he's being kept home. So this grandma called Pat Owens, and Pat Owens, the educational consent law in Maryland had just passed, and she got herself a copy of the law and got in her car and drove down there, and the three of them went to the high school with the custody order in hand. I mean, not the custody order, the affidavit in hand, and enrolled Johnny that day. So, you know, that's a great story of just advocates rallying. Anyway.
Right, and
go ahead.
It's a very typical way that, you know, what happens is a caregiver is faced with a problem that they didn't expect, and how can they fix it quickly? You know, even if that caregiver decides later on, oh, I think I should get custody of this child, I want to go through the court systems to do that, there's still probably going to be a year's time where you need the affidavits to cover any decisions you have to make about health care and education, because it takes so long for a custody case to make it through the system.
Yeah, and that's specifically what the lawyer I talked to in Seattle does. She often uses the affidavit in the interim until that legal custody order gets issued.
Right.
Great. Thank you. Well, I want to acknowledge that we have just a few minutes left, and it looks like that concludes the questions that we have. We did have one question come in, again, repeating about access to the PowerPoint. So just to make sure that that's clear, after this webinar, all of you that are registered will receive a link to the recorded webinar, and in addition to that, there'll be a separate place with a link to the PowerPoint where you can download the PowerPoint itself so that you can have access to that. So you'll be getting a link from us with access to that information. And with that, unless there's any last remarks from Joan and Anna, I want to say thank you very much to our presenters, Joan Little and Anna Beltran, for today's presentation. You should feel free to follow up with any of us with questions that weren't answered on this webinar. And beyond that, we look forward to sending out links to the key information, and we hope this was helpful for you. As a reminder, there will be an evaluation that's sent to you after this, and we'd love your feedback on how the webinar went. And with that, we will end it. Thank you very much.
Thank you.
Thank you.